All right, what is the deal with the debate on witnesses during the Senate trial on impeachment? Viva Frei, Montreal litigator turned YouTuber, and this is Barney the Vlog dog who has not been behaving this morning and may have a limited amount of time in this vlog. What is going on with the debate about witnesses being heard at the Senate trial on impeachment? It's something that I've been struggling to understand myself. I thought I had a handle on it, but then reading the headlines, I started questioning whether or not I actually understood what I thought I understood. And I recently did a live stream with attorney Robert Barnes, and I've got to tell you, it was among the most informative live streams that I've ever done. I learned a ton out of the live stream. I'm going to link it right here. Give it a watch. It's long, but sometimes learning things takes time. So what is this whole deal with whether or not witnesses should be heard in the impeachment trial before the Senate? It has become a talking point, the wording of which varies depending on what news source you're reading it from. If you go on social media like Facebook, Twitter, etc., you will see people repeating a talking point to the effect that Senate Republicans are refusing to allow witnesses or evidence in the impeachment trial before the Senate, and that is just not accurate. The more accurate way of phrasing it would be that the House Republicans are not allowing additional witnesses or additional evidence to be presented at the impeachment trial before the Senate that was not presented before the House when they approved the articles of impeachment in the first place. All of the evidence and witness testimony that was presented before the House when the House approved the articles of impeachment is available for the trial before the Senate. What the Senate Republicans are saying now is that we are not allowing additional witnesses or additional evidence that was not adduced before the House when the House approved the articles of impeachment. So in order to understand this, we really need to flesh out the two phases of the impeachment process. You had your impeachment inquiry before the House of Representatives in order to determine whether or not there was sufficient evidence to approve articles of impeachment to submit to the Senate for trial. In the context of that inquiry, indeed the very object of that inquiry was to adduce evidence to determine whether or not it was appropriate to approve articles of impeachment. House Democrats made their evidence, they called their witnesses, and they voted on articles of impeachment, and they approved articles of impeachment based on that evidence. The House approved the articles of impeachment as drafted based on the evidence and testimony that was provided, and they then submitted the articles of impeachment to the Senate for a trial on the merits. The House has the sole power to impeach, and the Senate has the sole power to have the trial. And we are using the term trial here because by and large it does follow the process of a trial. But we also know that the trial before the Senate doesn't actually necessarily follow the federal rules of procedure or anything of that nature. Indeed, the Senate establishes its own rules for the trial before the Senate. And it is precisely those rules that are at issue right now, whether or not the Senate should approve rules that allow for additional witness testimony and additional evidence to be presented in the trial before the Senate that was not presented before the inquiry before the House. But one thing is for certain, if anybody says that the House Republicans are not allowing witnesses or evidence in the trial before the Senate, that is oversimplified to the point of inaccuracy. All of the witness testimony and evidence that was heard before the House will serve as evidence in the trial before the Senate. The only question right now is, does the Senate agree to hear additional witnesses and additional evidence that was not presented before the House in the impeachment inquiry itself? And for that, at least for the time being, the answer is no. House Republicans are saying we are not going to allow any additional testimony or additional evidence that was not already presented before the House in the trial before the Senate. And depending on your political orientation, you are either screaming this is a massive cover-up, they are denying witnesses and evidence, or you are saying you made your bed, now sleep in it. But let's break it down even more to make sure everybody understands. In the practice of law in Canada, and from what I understand it's the exact same thing in the United States, we no longer have what is referred to as a trial by ambush. When somebody initiates proceedings, there's a whole process that the parties need to go through in order to get their file ready for trial. You have your written pleadings, you have your statement of claim, you have your defense and potentially counterclaim, you have your answer to defense and possibly response to counterclaim, you have depositions, examinations out of court, communication of documents, and at some point the parties say, okay, we are ready to go to trial now. We're going to fill out a form, announce what our documents are going to be, who our witnesses are going to be, what depositions we'd like to file. You have disclosure, confirmation, and communication of all witnesses and documentary evidence that you are going to want to invoke at trial. And these rules are in place to prevent one party from ambushing the other party come trial time. Depending on your jurisdiction, it can be called a joint declaration, but you literally have a document that the parties fill out and they say, these are going to be our witnesses, these are going to be the documents that we're going to refer to, so that you can take cognizance of it and prepare accordingly. It's no longer the case that a party can show up to trial and call any witness they want without having given any advance warning to the other party. It's no longer the case that you can show up to a trial and drop a bunch of documents that the opposing party has never had a chance to consult. So the whole idea is that the parties get their trial ready for file, they disclose all the information not only to the other party, but to the judge who is going to be hearing the file. Because typically the judges take cognizance of the entire file before the first day of trial. They read through the proceedings de part et d'autre, meaning from one side and the other. They look at the depositions, they read through the transcripts, they look at the exhibits. The rules prohibiting trial by ambush were done not only out of courtesy and fairness to the opposing party, but to the entire system itself. Judges don't like it when one party springs additional evidences or additional testimony come trial time when they have prepared for the trial based on the state of the file at the time it was submitted to the court. That's a big sentence. And so this entire process is analogous but not identical to the impeachment process before the House and Senate. As a precondition to drafting and approving the articles of impeachment, the House heard witness testimony. The House saw evidence. They couldn't possibly have drafted and approved articles of impeachment unless they saw sufficient evidence to warrant that. And the idea is that the House built its file, approved its articles of incorporation, and now submits the entire file to the Senate for trial. In theory, there's good reason to conclude that no additional witness testimony or evidence should be necessary to convict in a trial before the Senate if it wasn't required to approve the articles of impeachment before the House. In other words, if there is witness testimony and evidence that is necessary in order to convict, it was necessary in order to approve the articles in the first place. If the House drafted and approved articles of impeachment based on the state of the file that they built before the House, that is the state of the file that should be submitted to the Senate for trial. Now, in response to that, you are going to hear people rightly say that in the Bill Clinton impeachment, additional witnesses and evidence were adduced at the trial before the Senate. And so there is precedent to suggest that the Senate can agree to hear additional witnesses and evidence at the trial before the Senate, but there is no requirement to do so. Another counterpoint that you're undoubtedly going to hear, indeed it serves as the basis for the second charge in the articles of impeachment, that being obstruction, is that certain witnesses, despite being subpoenaed to testify before the House, were blocked from doing so either on the basis of executive privilege or other reasons. And so to that extent, to the extent that those witnesses were blocked from testifying before the House in the impeachment inquiry, they should be called as witnesses before the Senate trial. The counterpoint to that counterpoint, and it's in fact exactly what Jonathan Turley raised as an argument during the impeachment inquiry hearings themselves, is that the House should not rush through the impeachment inquiry. If there are debates as to the legitimacy or validity of the subpoenas, they should go through the judicial system to validate those subpoenas.
And I would say that what Trumbull said has even more bearing today, because I believe that this is much like the Johnson impeachment. It's manufactured until you build a record. I'm not saying you can't build a record, but you can't do it like this.
And for whatever the reason, the House pushed through with the impeachment inquiry without validating the subpoenas so as to compel those witnesses. To the extent that they did not pursue the matter judicially to validate those subpoenas and compel the witness testimony, instead they chose to pass the articles of impeachment on the basis of the file that they had, they should be precluded from doing so in the trial before the Senate. If they wanted to compel the witnesses to testify who were defying the subpoenas, all they had to do was pursue the matter judicially, slow down the impeachment inquiry before the House, build their file, then take it to the Senate for trial, which they did not do. So that is the point, counterpoint, counterpoint. Legal Eagle, in one of his recent videos where he reacted to Adam Schiff's closing speech, put up a statistic to the effect that 70% of Americans want additional witness testimony in the Senate trial.
Wow. Holy shit.
And the funny thing is, I do not doubt the accuracy of that statistic. Let's just take that statistic for granted. 70% of Americans want additional witnesses in the trial before the Senate. For the sake of simplicity, let's just assume that 50% of America is Republican and 50% is Democrat. And let's just assume that 100% of Democrats want additional witnesses. That means that 40% of Republicans want additional witnesses in the trial before the Senate. I can accept the fact that 70% of Americans want additional witnesses during the trial before the Senate. I can guarantee you, however, that they do not want the same additional witnesses in the trial before the Senate. Democrats want certain witnesses and undoubtedly do not want other witnesses. And I can guarantee you that Republicans undoubtedly want the very witnesses that the Democrats do not want. And this is where you can appreciate that the rules prohibiting trial by ambush were not just done for the benefit of the parties, it was done for the benefit of the procedure. Because when it comes time for the trial and the file is supposed to be in order for the trial, when each party starts throwing in additional witnesses, the entire process goes haywire. And it would not be difficult to imagine how haywire the trial before the Senate can go if both parties start calling any and all additional witnesses that they want. Democrats are going to want to call Bolton, Giuliani, etc. Republicans are going to want to call the Bidens, Schiff, Nadler, the whistleblower. And what is supposed to be an orderly trial before the Senate quickly degenerates into absolute mayhem. It is why, at the very least in the practice of law, barring exceptional circumstances, the parties are expected to go to trial on the file that they have built. True, it happens that witnesses die, and as a result, you need to get other witnesses to compensate for that lost witness. There are exceptional circumstances where there was the subsequent discovery of earth-shattering evidence that needs to be put in the file. But even then, you leave room for disclosure, communication, and discovery on that additional evidence. And depending on the necessity of the additional witness testimony or evidence and the proximity to the trial, sometimes the trial has to be postponed. The trial needs to be postponed so the parties can take cognizance of this additional evidence and reshape their file if necessary. And that is exactly what is at stake in the trial before the Senate. Democrats are saying we need additional witnesses, we need additional evidence for the trial before the Senate. Republicans are saying if you needed additional witnesses and additional evidence, it should have been done before the House prior to approving the articles of impeachment. If you need those witnesses and that evidence in order to convict on the articles of impeachment that you approved, did you not need that very same evidence in order to approve those articles in the first place? This is what is at play in the dispute on whether or not additional witnesses and evidence ought to be allowed in the trial before the Senate. There is precedent that allows for it if we go back to the Bill Clinton impeachment. However, if we're going to argue based on the precedent from the Clinton impeachment, well, there was other precedent precedent that was not followed this time around. Most notably with the Clinton impeachment, there was a formal vote to approve the impeachment inquiry. Also in the Clinton impeachment, there was a minority day hearing. They got to call their witnesses, which was not the case in the Trump impeachment inquiry. The House minority Republicans never got to call their own witnesses in the impeachment inquiry, which is why you're going to have people taking issue with the argument of precedent this time around, because right now people are arguing precedent for one issue when precedent wasn't followed on other issues. And that is the unfortunate, dirty nature of politics. So I hope I got that sufficiently right. I think I did, and I hope in so doing it will allow you to come to a more educated opinion on the subject. We should be very wary about parroting talking points that have been boiled down for simplicity, but potentially boiled down to inaccuracy. It is a nuanced debate, but a nuanced debate that is nonetheless filled with double standards, but that is par for the course when it comes to politics. If you like this video and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. If you want to support the channel, merch links are in the pinned comment with a PayPal option for anyone who's so inclined, and now you know your vlog. Peace out. Booyah!